There is. What are we doing today?
Motion to withdraw, Your Honor's counsel.
This one's already off to a tense start. A defense attorney wants to withdraw just before trial. Wait, what? Let's see what's got this case on the verge of collapse after * 2.5 years.
Why?
Well, for one thing, he's not going to pay me anymore, I don't think, at all. I've been without pay for a number of months. And, we're supposed to be coming up to trial.
When is this trial set? When was this on? Please? June 2nd? No, that was the last.
That was the
event.
last day. I don't think he had the present setting. I know of.
Yeah,
When we had hearings.
setting for the hearing, it got erased.
Yeah, we had, the last trial setting was in March, Judge.
And this is this is 2.5 years old, and now we're not getting paid?
No, I just worked with him, tried to get payment, and now he doesn't pay. He hasn't paid for several months. I'm not sure what his problem is. He never talked to me about it.
I don't get involved in this, but
The defendant claims no motion work has been done and blames poor communication. Do you think he's got a point, or is this just a delay tactic? Let us know what you think below.
is there a problem?
Yes, very much so.
What is it?
It's black and white. None of the things that I've asked him to do have been done. There's no motions on my end. We're here around 2.5 years later, as you said it yourself. I mean, this shouldn't be going to trial. It's a waste of money for the state. It's a waste of money for myself and time. It all started with the police investigation. I've never talked to police once. I've never talked to this man to be able to talk to him to get through the state and say, hey, this doesn't need to escalate. We need to save the state some money.
That's wonderful. He should know this is an aggravated assault case. Either the guy or, he was self-defense.
When did you get hired, please?
I got paperwork today, and then he was retained May the 24th,
Maybe 24th.
Of what?
2023.
Okay, 2 years.
2 years.
So 2 full years goes by, and now you're filing a motion to withdraw because he hadn't paid you?
In a while. I think the last time he paid me was before December.
Right.
He thinks probably he paid me too much. I don't know. I don't know what the heck he's talking about as far as motions. He wants to talk to the police. He doesn't have the right to talk to the police. And it's if he asked me more fundamental questions, maybe I could explain it to him. But now I've got expenses. I've got to travel. He's known since December that I've been moving to Longview. It cost me some money to come down here and try the case. So I was just trying to get it's going to be 3-day trial.
Mm-hmm.
And he needs to at least pay me for the 3 days of my expenses.
It's also been my experience that sometimes you end up getting.
This is where the judge gets visibly frustrated. 2.5 years and they're still arguing over attorney payment. You can feel the court's patience running thin.
As an attorney, then it's not a good deal. It happened to me when I was in private practice. You get stuck, and there are legal ways of handling that. But what disturbs me is this has gone 2.5 years, and now I'm looking at I'm being presented with something that is far overdue for trial, and y'all are bickering over a civil contract that isn't being worked out.
Well,
That's not for the court to resolve. It's not for the court to resolve. You got a problem with him? There's a bar. There are agreements that you can file.
I completely agree.
If that's what you want to do, you assumed a responsibility to represent it, and that you can't do 2.5 years really, and then whatever money has been paid, I don't know. I don't want to get into that, but some money had to have been paid.
Yes.
And this is overdue for disposition. And what we're going to do things. I can release you, then we have to start over with another lawyer. And that won't be fair to the people, which is my first responsibility, as well as the constitutional rights of defendants. But moving a trial forward without unreasonable delay is foremost. And I don't get these problems. These are always worked out. But I also know lawyers end up losing money on some cases. It's a responsibility, though, that they deal with. If you're indigent, are you indigent? Are you able to pay? Do you
No.
have a job?
No, I beforehand I did have a job. Now circumstances have changed. I don't have a job. I haven't had a job for the past 5.5 months. I'm working on getting a job. This is delaying on me getting a
Okay,
job.
so you don't have an income right now?
No, I do not have an income.
All right.
I didn't understand. I didn't know that.
All right.
Either fully. I know I gave him a little time because you
Okay.
should find jobs.
He can
easy.
look.
Okay.
You
But the thing, excuse me.
you can.
Interesting move by the judge here. He's giving the defendant a chance to file as indigent. That means the court might pay for legal defense if he qualifies. What would you do if you were the judge?
Can continue to first of all, you've spent the time, you've gone down the road on this. I'm not going to start over. If you come to me later and apply for indigent funds to help you in this case, I'm happy to
Okay.
consider it.
Sure.
And it doesn't happen often, but it's happened before, and those have been granted. Reasonable fees have been granted, but I want
Sure.
your 2.5 years and yours. Y'all fix this together. Work together,
Yeah.
please. It's in your best interest, in your best interest.
Oh, definitely.
I didn't know I could apply for.
Well, it doesn't happen
Right.
normally, but there's always an answer to every unique situation that this court over 18.5 years has had to deal with. But we just don't open the door for the people to pay. Y'all work it out. But if his situation has changed and he's unable to pay, then he needs to fill out an indigent form
Yes.
before he leaves, so that can get into the record. If it changes, you have to let me know, or else you're in trouble. So you get a job, fine. You take, start accounting for your time that you would ask for reimbursement for while he is indigent. But this moves forward, please. I'm going to be kind about it. I'm demanding I'm ordering it to move forward. Y'all had enough time to prepare, get to the finish line one way or the other, however this is going to be disposed of. Okay? Is it Mr. Ham on this?
Yes, sir.
This doesn't look like a real complex matter. It could be, but
I've got it whittled down to 3 witnesses, Judge.
Yeah.
The judge is setting a firm trial date. No more extensions. This is the final countdown, and the pressure's on both sides to get it together. Next voice.
there's no reason to delay 2.5 years on 3 witnesses. Come on. Now, y'all's business is yours, but the state, it's succinct. It's obvious.
The only thing that is the 2 of my witnesses will require an interpreter.
All right. And if it's not going to be disposed of by a trial, let me know so we don't spend time and money preparing for a trial. If it can be worked out, let me know. If not, let's try it. But what's it set for, Helen?
I can put it on the 25th when Mr. Cobb is here already. That would be.
No, he's not going to be ready. I'm going to give me another month, please. We're setting this, y'all. That's the finish line.
The 22nd of September,
Okay. That's
22.
All right, that's set on that date.
We'll make sure.
If
I'll
I
work together.
correct, if I may say, one of the things that I want to bring up, obviously that was a sideline for me from
Yes,
the
sir.
get-go. I want to bring up, I also want to get this over with and situated, which I'm willing to to talk to Mr. Croft, see if we can continue this, because in reality today, I got served with this paperwork on the 24th of just the other day, saying, this motion for him to get out.
Yeah.
But we realized this before in our previous time that we came here, when he didn't show that he wasn't gonna no longer be here to partake in this. I came here on my last continuance. I was never even called up here. I showed up in the morning. I was on the court docket online. No one gave me an explanation. I just waited for the bond people to call me. I mean, I don't know how it slips through the cracks, or who gets, but at the end of the day, I'm here.
Trying to explain that.
Look, when motions are presented, when motions are filed, that doesn't get my attention, because I've got 2,500 cases, 2,500 cases. So lawyers know they can file a motion, but I'm not going to even know about it unless it's presented. We call it presented. They've got to present it to me, get my attention, and get everybody together, and then I will conduct a hearing on it. The fact that it's filed, that doesn't get to the finish line. You have to present it, and then we'll take it up. It would be enormous. And most motions, strangely enough, are never presented. They file them, and they sit in the file, and then they get shredded at the end because nothing was ever done about it. Nobody ever presented. Nobody ever moved on it. They filed it. It seems to me a waste of effort, but until it's moved by the parties, one party presents it to me, we have a motion, we want to have a hearing on it, and then I'll do it. Because most motions they're filed and then they're never moved on. And that's the party's business. So that's what the court does. I couldn't deal with all those on my own anyway. It would be impossible, but it's unnecessary because they're pro forma. They're some just formality in many cases. And until it gets serious, then I'll be able to move on it. In y'all's case, work together. The team is more powerful than individuals working in different directions for the same goal. You represent him, and you got your interests here that are at stake in your constitutional rights. Work as a team. That's the way it's always done. We never have problems. Fix this, and that's in your best interest and everybody's best interest. Okay, it's set for trial. If most cases are disposed of without a trial, 95% are disposed of without a trial. If that's the way it's going to be done, let me know, and then
that's the route that I would take. Yeah.
If it has to be a trial, we've done 600 trials, so we're not afraid to try cases, and that's what this is for. Okay, fix it. Be ready for trial, or let me know otherwise.
Thank you.
Okay, thank you.
Thank you. Good call. I got it. Okay.
But
How you doing, Carl? How you doing? Mark, how are you?
you're leaving now?
This is a skill that the state, I believe, is not.
Judge, this is an old colleague of mine, Mark Lambert. He represents one of the banks that Bruce Cobb has tried to subpoena records from.
Colleague
Yes.
of yours?
I don't know if that's a comment on me personally or.
He's he looks fairly young, Your Honor.
Well, when y'all stand close to each other, yes. He does. Bruce, a couple of things here that jumps out at him. As you know, this thing's 4 years old.
Right.
It's too old. We got to move forward. So how are we going to do that?
I'd like to get that discovery so I can defend this case.
Well,
what's
okay, so let me respond to that, Judge. If his contention is that he's going to utilize this discovery to defend this case, that is absolutely ludicrous. That it's the amount of loss is not even an issue in the indictment. There is no complainant listed in the indictment. That'll be his next thing he points out, which is that the complainant really recently passed away. So if this discovery is designed to determine the restitution and he wants to resolve this case, then yes, I'm for it. But the amount of loss simply isn't an issue. And I've always agreed to a limited version of producing this discovery under the assumption that he was trying to get it to make arguments about what the restitution should be.
Well,
But if
yeah,
he-
but it's a lot more than that, relative.
It absolutely is not, actually.
To the fraud, because of essential evidence.
Okay, well, how does that amount of loss have anything to do with intent to defraud? One shred of
In
evidence.
this case.
Okay, well,
But you know, it should be very relevant to the amount of restitution, if it is.
which is not something the jury even determines.
All right, y'all through? What is it everybody wants?
Okay, Judge Mark Lambert, I'm here for Do Good Credit Union. I guess I'm the point of contention here. At this point, we've received a subpoena. We've objected to the subpoena for the records that Mr. Cobb are referencing. Under Section 59 of the Finance Code, the only possible way I can produce these records for Mr. Coon, whose records are being sought, is if he is served with notice and has the opportunity to object and signs a waiver. Otherwise, the financial institution can be held responsible for releasing privileged and private information and offered information. Obviously, that didn't happen. He's now passed away. The only other opportunity for Mr. Cobb and Mr. Eckert to get these records, if the court so desires and grants, is if the court will sign an order for us to provide the records to the judge for an in-camera inspection to determine the scope of the records that would be either admissible or discoverable and any redactions therefore. I don't think I can technically redact until the court says these are the records we have to produce. So we have a subpoena sitting on us that is due. I have objections that I filed with the court. I just don't know the scope of what the court will require me to produce to the party.
What do y'all say about what the gentleman just said?
Well, Mr. Kuhn was supposed to have gone and done a waiver, which we had agreed that he would sign, but he never got around to signing it because he passed away in the process. I've been a lot better than for.
We know he's passed away. What are we going to do about it? We can't change that. We move forward, and
Right.
we're moving forward one way or the other.
Yeah.
The passing away of an important person involved in a lawsuit doesn't scuttle what the grand jury has indicted. So we move forward.
Judge, I think you need to order the bank to give you the
Yeah,
records in camera.
Yeah.
That seems to me the proper way that this court has control over the situation, and all the parties are placing it into the hands of the court in these pretrial matters, which I think is where it needs to be. And when there's a disagreement of the way things should be. What I want from the bank is a proposed order, please, that
Probably has one.
fits with what you deem under the law is the way to proceed, that also is in the best interest of your client's liability exposure. And I can appreciate, my dad was about her, so I will appreciate and the caution. But this is 4 years old.
We should have-
It's way too old.
We had worked on an order. And I think,
I have a motion to compel discovery here back in January, from January, and then an order granting a protective order here. This was this presented by?
I think it was a mutual document drafted by Mr. Cobb and I initially to protect us until he could get the waiver signed by Mr. Coon. And I think at the end of that order, if I remember correctly, is the section 59. And it sets forth the documents that he wanted and that we would be protected.
Have you seen this?
I believe I have.
Any
Judge.
objections for me signing this?
What's the scope of what's to be produced?
It's that same thing that I mentioned.
Well, Bruce, you
Yeah, when you do it, it bothers him.
yeah, because it's way broader than what we talk about.
He's always grabbing for his wallet when you're near him, Bruce, for some reason.
And just so we're on the same page, Your Honor, we're talking about a lot of records. They haven't been sifted through by the bank because we didn't know the scope. So I can narrow it down to whatever scope that the work orders or the parties will be on. I just need some guidance.
Yes, this number 2 here is the scope of what I've agreed to obtain for them.
I've got both Mr. Coker and Mr. Cobb's signature on this.
Sure.
Okay, that will be made a part of the record, and we have a defendant's motion to compel discovery and request for hearing this.
Well, I think
What
that's
else?
moved.
Go ahead. It's moved.
We already had
You
that.
withdraw this then?
Yes.
Okay, then. So what's next on this 4.5-year-old case to move it forward? What do we?
They're going
what
to
do I need to do?
they're going to submit an order.
Okay.
Yeah.
All right. Well,
They've yet to
that
tell
may or
me.
may not work depending upon what's going to be necessary for preparation, but it'll stay there on that docket, and it'll be at least a goal for us to reach.
Right.
To try to reach. What else do we need to do today that you need from me?
I think that's about it, Your Honor.
Okay. From the state, how many witnesses are you guessing you're thinking about? That may be
5 to 10.
Okay.
5 to 10.
All right. Anything else?
No, they can't have that.
Then we'll see you back in August, I guess. Try to do what you can to be ready. When,
And the documents will be submitted to the court, set up the different.
Absolutely. We'll submit an order to Mr. Eckert, Mr. Cobb, and have that to him this afternoon. I can have the records to him next, or to you,
All right.
Judge, next week.
while we got this,
Yes.
so I'm not in the dark.
Uh-huh.
That's because I don't know. I don't know anything about the facts of this case. I can look at the probable cause, and that's all I can see. What is it that each of the parties are asking me to be wary of and to pay attention to?
Well, for one thing, I think they're going to have his co-defendant testify, and I'm going to have to
No, I'm
probably
talking about the records.
the records
Yeah, I'm not talking about that. I'm talking about the records.
outside of the proper deduction.
I'm going to get a bunch of records here,
Yeah.
and I want to be able to sift through what's relevant for me to look
Right.
at and what I don't need to spend the time looking at.
Well,
What's the defense?
part of the thing that we are contending is that this was a normal construction. Somehow, this was a construction case that went awry, and the complaining witnesses stopped the work, which is rare. The normal case would be like a roofer. When you give $20,000 to a roofer and he starts to work on it and he doesn't complete the job and he runs off. This isn't the case at all. These people worked on the job until fired. They were fired by the Coons, and for some reason, the Coons also sold it, did a sub sale, and also had debt forgiven by the do-good. And what this does is it pretty much cleans it up. There was no intent to defraud, ever.
I'm not asking for your final argument. I'm just asking for what is it that I need to be paying attention
Well,
to.
that-
Your
okay.
view in these gigantic
I need
records.
to find out if the Coons ever put some money up front that was never
In the records.
in the records.
What is it
Right.
in the records I need to be looking at?
Well, that's just partly it. But the thing about it is how the do-good controlled the draws and gave the money to Mr. Coon. And Mr. Kuhn was the one that gave it to the co-defendant. And then the co-defendant actually had him, supervise the work on the job.
Okay.
That's what it is. This should have been a civil case. And Your Honor, there's one other
Okay,
thing.
the grand jury thought otherwise. That's the way it
I don't
is.
think the grand jury ever saw that there was a $1 million.
You were in the grand jury room,
involved.
that would have been an illegal act.
No, I
You don't
don't
know, Bruce. Can't talk for them.
Even
And
so.
you trust that they're gonna abide by their oaths. And until you tell me otherwise, don't badmouth the grand jury.
No, Your Honor, but this is a
Don't
complicated
criticize
case.
the way that this is done unless you have something to say about that's articulated. They came up with an indictment and,
Fast forward to a different case. This one's been dragging on for 4.5 years. The judge just said it's time to fast track it. Can they finally get this show on the road?
grand juries, from my experience, they don't dream it up. And it's probable cause. This is beyond a reasonable doubt. That's the big difference. But don't be arguing, a grand jury indictment. It's there. So we're dealing with it and we got to move forward with it. That's a waste of time. Unless you could say that the grand jury did something wrong, which I've never had that presented to me in 44 years. Okay, from state.
I would urge you to go through the redactions with a heavy hand because it is virtually pointless. What he's describing is nothing that is relevant to this indictment of whether or not this man misapplied trust funds. The only reason I've even agreed to this is because it's taken him 1.5 years to get this.
Okay, well, we're fast tracking. You got my attention, which is going to move this case forward. From the third part.
How would you like them? I can do them in paper form, digital, zip drive, whatever the court prefers, and it's easiest for you to review. And representation.
Well, everybody's going to get a copy of this.
Once you've had your, just like with CPS records, Judge, you have to decide what is redacted first. And I will say for the record that typically when CPS like this, CPS often produces records in camera like this for this court to review. They submit proposed redactions with their records. I understand that may take you longer. However, that often is what the court looks at and relies on.
Okay.
Just so you know.
I guess hard copy is easy to. Nowadays, I really don't know. I'm just used to hard copies.
You're talking about thousands of pages, though.
Judge, how about I do both? Hard copy and a zip drive. Would that be easier?
Yeah, because I can pass on those to the parties. It's easier without getting a pickup truck. Okay, let's see what we can do quickly, and then we've got an August trial date.
Thank you, Judge.
Thank you.
Thanks, Judge.
We'll be here.
You've got Roberto Mears.
Yes. Who's the next one? Well, yeah, but I need to see, see.
What are we doing today? Oh, you don't know. Well, it's a review of.
Yes.
Okay. And
Ultimately, Judge, if I may, just to bring you.
are you representing him?
That's what I had to hear.
There's a.
No, I'm sorry. Never mind. No. I thought it was, never mind. I'm sorry.
Thank you for your appearance, though. It was nice.
Judge, I can bring you up.
It's a fee issue.
Yes, sir.
Okay. There's a motion to revoke probation that had been filed last year. And this is about, these are done as you're nearing the end of probation. You were on probation for 10 years for aggravated assault. Well, it says 8 years. And then it was extended 2 more years. From 2014, when you were placed on probation, August 11th. So 8 years have been in 2022. Then it was it was extended to August of last year. And before that anniversary of 10 years was reached on August 11th, or it would have been, yeah, August 11th. Then July 9th, a month before that anniversary date, a motion to revoke probation was filed, which is normally done when there's a fee issue. They get a foot in the door so the door doesn't close. It would close if nothing is done and 10 years elapses, then you would have been terminated from probation. But in your case, it's all about restitution.
Your Honor.
It looks like. I mean, there was a lot of restitution ordered at the beginning. I don't know what the balance is, but it looks like it's a little under $50,000. So that's why we're here, is trying to collect money for the victim.
Actually, Judge, what we were here today for is USD.
Correct.
Well,
Go ahead.
it's an administrative thing. The question came up about why the victim hasn't been receiving restitution. The defendant complained about that. You asked the probation department to look into it.
I'm concerned about victims.
Judge, the reality is that the victim was compensated through the Compensation Act, and we had to pay them back first. They've approved.
Wait, paid them back. Them is the victim compensation
Yes,
entity.
that's what's been happening. We needed to get the numbers on that. She's prepared to give you the details as to all that.
Somebody's paying it.
Yes.
And it can't be, if it's Victim Compensation Act people, that's the taxpayers. And I'm not interested at all in being part of paying restitution that I wasn't responsible for. So it's the responsible party ultimately absorbs the cost. Sometimes a government entity is formed to help the victim get their money as soon as possible. Then the governments, the taxpayers, the people who funded that, actually to get to the hands of the victim as soon as reasonable, then it gets repaid so that the taxpayers aren't footing the bill and paying for an indebtedness that they weren't the cause of. Then that's your responsibility at the end, Mr. Moten, that you've been trying to handle.
So we've got the breakdown for you, Judge.
All right.
Judge, if I may, the crime victim compensation paid in $9,237. Again, that's $9,237.91. And once we had the number for the CBC, all the restitution, 100%, was going straight to them first to get them paid off. As of June 13th, 2025, just recently, he paid his $500 that he worked. The defendant paid his $500, and like I said, everything was going to CBC. He is currently paid off CBC in full. So now moving forward, any restitution that you order, $500 each month, is going straight back to the victim individually.
How much, what's the balance for that?
The balance on
I think that's what we're all interested in knowing.
that is
He needs to know when his $500 payments stop.
his balance on that's going to go to his father, the victim, is $42,731.29. And he has been making his $500 that you've requested monthly. Now the full $500 will go to his dad, the victim, moving forward.
Which is a balance of
Yes, sir.
$42,731.29.
Yes, sir.
You understand that?
Yes.
Mr. Moten. Well, that's, we're talking about 83 months. I mean, it's a lot of time, but it's what it takes to fix the mess.
Yes, sir.
Okay. So
He's
we,
paying
good.
second.
Otherwise, he's on an inactive state.
He's been that way for over 2 years.
It's
Judge.
just a matter of him coming in monthly and making payments. If you happen to win the lottery, don't spend a lot of money on that, because that's a losing deal. But if you happen to win the lottery, that can help pay this off.
Yes, sir.
But keep doing it in a responsible way. Okay, the victim is your father.
Yes, sir.
I don't mean to be,
You've already addressed that, Judge.
working out.
Yes, sir.
Okay.
I ain't allowed to see, right?
Yeah, we've addressed all that through a memo that was handled 2 months
If
ago,
the
Judge.
victim wants That's what he wants.
We've
Yeah, I'm all for a father and a son
Yes, sir.
repairing any problems.
That's all been monitored by the probation office through your efforts and what you asked of everybody, Judge.
Okay, good. Well, we're putting the family unit back together, and the other way is repairing by the loss, and that's how you fix it. Okay. Then I think we'll just review in 6 months, just to kind of keep an eye on things. Is that okay? Thank you very much, everybody, for being part of this. It looks like this is working. Appreciate it.
I think that's all for all the comments. Yes. But now, okay, just want to make sure if something changes, you need to listen.